2026 meeting of the House Public Safety Committee to order. A quorum is present. Before we begin our meeting, I want to remind everyone that the committee chair maintains control of this hearing, and I have the following expectations. Signs and placards are not permitted in the hearing room. Verbal outbursts, shouting, or disruptive behavior will not be tolerated. Applause or other audible demonstrations are not allowed. For safety reasons, standing or sitting in the hallways and alleys or standing or obstructing at your seat is prohibited. If you require accommodation, please speak to our sergeant staff identified by the gold ties. Troopers and house security are present to ensure everyone's safety. If you received an entrance ticket, which I believe were sold out, so this is important, please retain your tickets as it may be required for re-entry if you leave the hearing room. Failure to comply with these guidelines will result in removal from the hearing room. Thank you to the sergeant and our staff who are present for helping maintain order and decorum in the committee room. Representative Bliss, have you had a chance to review the minutes of the March 3rd, 2026 meeting?
I have, Mr. Chair, and I'd like to move them.
Representative Bliss moves to approve the March 3rd, 2026 minutes. All in favor signify by saying aye.
Aye.
All those opposed say nay. Motion carries and the minutes of the March 3rd, 2026 meeting are approved. The first bill on our agenda is House File 962. This is my bill. Representative Witte, please take the gavel while I present my bill.
Chair Novotny, would you like to move your bill before the committee with a recommendation that the House file is re-referred to the Committee on Judiciary, Finance, and Civil Law?
That is my motion.
Chair Novotny, please begin your testimony.
Bill 962 is in regards to what's commonly referred to as the Brady-Giglio bill. Brady-Giglio refers to a list of law enforcement officers that prosecutors keep who have allegations of untruthfulness or other incidents that call their credibility into question. There have been varying criteria prosecutors use to determine who gets put on a Brady-Giglio list. I authored House File 962 last year to put some standards, some uniformity and protections in place for this Brady-Giglio list. The bill includes the bill included a task force composed of stakeholders to come up with a uniform statewide standard for the Brady-Giglio list. We heard in February of last year, and although we did not pursue the statutory task force, I tasked the stakeholders with coming up with standards. The law enforcement associations and the county attorneys have been meeting over the last year, and they have come up with a framework for Brady-Giglio policies. Although I understand that there's additional work to be done on the data piece of this, and we hope to get that worked out before it goes to judiciary, the D3 amendment represents the work of the associations to date. So Vice Chair Witte, I would like to move to adopt DE3 amendment, and then I will have my testifiers come to speak.
Chair Novotny moves the adoption of the DE3 amendment. All in favor of adopting the DE3 amendment, say aye.
Aye.
All opposed, say nay. The motion prevails and the DE3 amendment is adopted. Please have your testifiers come forward, identify themselves for the record, and give the testimony. And first up is David Titus, Executive Director of Minnesota Police and Peace Officers Association. Next on deck is Mark Schneider, General Counsel, Law Enforcement Labor Services.
Good afternoon. I'm Dave Titus, Executive Director of the Minnesota Police and Peace Officers Association. Chair, committee, thank you for having me. We were summoned to give a progress report on this Brady bill, so I will not duplicate our previous extensive testimony on why there is a statutory need for fair, consistent, uniformed process of Brady application. County attorneys, chiefs, and sheriffs, the MPPA, our associations represent our respective professions, our respective members, and those members' priorities and interests. The MPPA represents rank-and-file cops. Those are our members, those are our priorities, their interests are our interests. Our position on this Brady bill has been consistent. We need a uniform Brady process. We need the ability to challenge a Brady designation. There should be no ability to discipline solely on the basis of a prosecutor's designation. The work done by the above associations has been positive. We appreciate the movement in regard to the ability to have Brady designation reconsidered and agreement that peace officer no-call lists cannot be utilized. That being said, as it relates to our original top 3 requirements, more work remains necessary for our full support in regard to the ability of a peace officer to request a third-party neutral review of a Brady designation, and a Brady designation alone cannot be the basis for discipline. With the goal of a fair process for Minnesota cops, we need 10 yards, and we've gained 4. At this point, in the interest of moving forward, keeping our advances and resolving differences, we support this amendment.
Thank you. Next up, Mark Schneider with General Counsel, Law Enforcement Labor Services, and on deck, Brian Wells, Cass County Sheriff. Go ahead if you want to identify yourself.
Yes, certainly. Thank you, members of the committee. My name is Mark Schneider. I am General Counsel of Law Enforcement Labor Services. LELS is a public safety union, the largest in the state of Minnesota with over 8,000 members. We represent public safety employees, including licensed peace officers, correctional officers, firefighters, and support staff in public safety agencies and offices. I've been working on the Brady bill for several years now. In fact, I testified before the committee last year, and I am happy to report and to say that there has been movement. But I would agree with Mr. Titus that while it's a 10-yard run to first down, maybe we are at 4 yards. And the reason I say that, and I think we are all in agreement and should be in agreement, that there needs to be consistency with a Brady-Giglio standard. And I think in my discussions with the county attorneys, I do not want to speak for them, the sheriffs and chiefs, there is consensus and understanding that that's important. I could be a Brady designated officer working in St. Louis County. If I relocate down to Mower County, I may not be Brady designated. There needs to be uniformity and consistency. We're getting there, but we're not there yet. The do not call list is a step in the right direction. There are also bargaining rights and grievance rights and rights under PELRA, the Public Employment Labor Relations Act, that relate to discipline within the agency. And the basis and the reason for the original iteration of 962 and the discipline prong of it was we are seeing, and I have personally experienced this as general counsel and counsel for other law enforcement officers, public safety employees, that a Brady designation, it's attempted to use that only for the basis of discipline without a deep dive into the facts supporting that Brady designation. And it's for these reasons that some sort of reconsideration review process is necessary. Again, the stakeholders have been talking about that and are moving in the right direction, but there is more work to be done. Thank you.
Thank you. Up next, Brian Welk, on deck, Jeff Potts.
Chair Novotny, Chair Moeller, and members of the committee, thank you and good afternoon. My name is Brian Welk, the Sheriff of Cass County. I'm here today on behalf of the Minnesota Sheriff's Association, representing Minnesota's 87 elected sheriffs. And we are in support of House File 962. From the beginning of this conversation around the Brady-Giglio policy and procedure, the Minnesota Sheriff's Association has had a seat at the table. We have participated in ongoing meetings with our law enforcement partners, prosecutors, labor representatives, and other stakeholders to help craft language that is thoughtful, balanced, and workable in real-world operations. This bill is the product of collaboration, not conflict. Sheriffs understand the importance of Brady-Giglio obligations. We know that credibility is fundamental to the justice system. When a deputy takes a stand, the integrity of that testimony matters to victims, to defendants, to prosecutors, and to the public. At the same time, we also understand the importance of fairness, clarity, and due process for the employees we supervise. House File 962 represents meaningful progress towards creating a consistent and transparent framework. It provides structure where ambiguity has existed. It promotes accountability while recognizing the operational realities faced by law enforcement agencies across Minnesota, from large metro offices to small rural counties. What is equally important is how this bill has been developed. The Minnesota Sheriff's Association values the perspectives of all the parties involved. We may not always agree on every detail, but we share a common goal, and that's maintaining the public trust while ensuring fairness in the system. We are confident that the continued work will result in a language that is acceptable to all stakeholders. The Sheriff's Association remains committed to staying at the table, working through the concerns, constructivity, and supporting a final product that strengthens both transparency and due process. Thank you, Mr. Chair and members. I'm happy to stand for any questions.
Thank you. Up next, Jeff Potts. On deck, Brad Johnson.
All right, thanks, Mr. Chair, members of the committee. Again, my name is Jeff Potts, Executive Director for the Minnesota Chiefs of Police Association, representing the more than 300 police chiefs across the state, as well as about 150 command staff members. First, I'd like to thank Chair Novotny for bringing this bill forward, as we feel there is a need for this type of legislation. I'm going to condense. The fine sheriff from Cass County covered a lot of what I was going to cover, so I'll mention just a couple more things here, but we just echo what you just heard from the sheriffs and as well as other testifiers. We do express strong support for a bill that will provide consistency and clarity on the issue of Brady-Giglio. After last session, and some of you were here and heard the bill, the debate that took place, the DE3 was developed in collaboration with stakeholders, led by the County Attorneys Association, but several law enforcement groups participated in those conversations. And in its current form, the bill does provide clarity on several really important definitions in Subdivision 1. Subdivision 2 provides consistency and clarity by requiring prosecuting authorities to implement a written policy to guide the process of determining how Brady-Giglio material will be handled. And Subdivisions 3 through 6 provide some additional clarity on how the data is to be used and secured. I will note that we are still working with the author and the stakeholder group on some provisions within the bill to ensure proper data retention of non-public data. We urge this committee to pass the bill here today so we can continue the work with the author and the stakeholders to address our concerns on data retention. I just want to say thank you for allowing us to be here today to testify in the bill. Thank you, Mr. Chair and members.
Thank you. Next up, Brad Johnson, and on deck, Jonathan Holitz.
Thank you, Chair and members. May it please the committee. My name is Brad Johnson. I'm the Anoka County Attorney, and I'm here today on behalf of the Minnesota County Attorneys Association. I've been leading the Minnesota County Attorneys Association Brady-Giglio Work Group, a group comprised of urban, rural, and suburban counties, for just about a year, following the leadership of past Sherburne County Attorney Kathy Heaney, who is now retired. Our work group has spent the last year putting together and refining a separate toolkit that is available for use by all Minnesota County Attorneys' offices in an effort to provide a consistent, predictable, simple, and secure framework to encourage law enforcement officers and public employee personnel data, to encourage the reliable management of that data in the context of Brady-Giglio related issues. We have also run point on working with our law enforcement partners to try to come to an agreed upon structure and statutory framework on Brady-Giglio material for you, the members of our legislature, to enact. That work has been very positive, as you've heard here today, and I'm grateful for the testimony of the other stakeholders who have reflected that as well. This effort's been a long time, or taken a long time, and candidly, we're not yet quite at the finish line. We're impressed with the speed that you all are moving with this season, and we think that that is good because it keeps things moving forward and it keeps us all incentivized to get to a good product for you. At the same time, we want broad consensus between the stakeholders responsible for carrying out this law. The language presented to you here today has yet to be blessed by our Minnesota County Attorneys Association Board of Directors, but it does reflect a reasonable framework, and it is a giant step forward by our work group that reflects those positive dialogues we've been having with our law enforcement partners. Indeed, we even met on it last week. You will hear today that there are some items that we still need to work out, primarily, and I really want to emphasize that this is a key one, the data sharing and security process. It is our hope that you will continue to give us the time necessary to work out and amend this legislation as it moves along to ensure that we can get it right and that all the important input is gathered and considered. We thank you for the time today and keeping this important issue before you, and I will now turn over to John Hollitz, my colleague from the North Shore, who has been instrumental in this work group to explain amendments that we've made to the bill for you. And I'll be here if you have any questions during the bill's discussion. Thank you very much.
Thank you. Sir, you can state your name and begin your testimony.
Thank you. Thank you, the members of the committee. My name is John Holitz. I'm the Deputy St. Louis County Attorney at the tip of the North Shore. I'm going to repeat some of the things you've already heard. Consistency, predictability, security. Those are things that everybody wants on this, in this group. The fourth thing that we need is simplicity, and that's the simplicity of the data access and data retention, and that's what, as you've heard, what we're still working on. As written, I hope that you see that this shows prosecutors' commitments to working with law enforcement and other public employers to address the concerns that they've heard in previous testimony before this committee. Again, we've heard it in a couple of different sports analogies now. It doesn't contain the most, from prosecutors' perspective, the most critical, important piece, and that's that data access part that we're working hard to get to the conclusion on. But the rest is really, I'm hoping you see, is a good faith demonstration of our commitment, of prosecutors' commitment, MCAA's commitment to addressing that consistency, predictability, security, those three parts with the simple data access to come. My hope was to go through a couple of the specifics in here and show you how we have encapsulated some of those themes, our commitment to that consistency, predictability, and security. Subdivision 1 is, of course, definitional, and I'm going to skip over that because it's not as germane, but subdivision 2, this is great examples of consistency, predictability, and security. This is requiring prosecutors to have a policy, implement a written policy to handle the processes of seeking, review, and reviewing personnel data and disclosing it when and if it's determined to be Brady-Giglio type material, disclosing it when it has to be done. It doesn't specify a particular policy, but it gives us some a really good floor to start from for some minimum policies. Of course, we've got 87 different counties, we've got an attorney general's office, and we've got a whole bunch of city prosecutors as well, and one size does not fit all. We recognize that, we know that, and so that's why we have some basic minimums, and as County Attorney Johnson alluded to, a toolkit to try to provide those tools to other members. Looking at subdivision 3, this again is another example of that consistency and predictability. It talks about and requires prosecutors to make these determinations, as they should under the law, on disclosure on a case-by-case basis. It also talks about and prohibits prosecutors from having this do not call list. And I know the importance of that. I understand the importance of that. It makes sure that prosecutors don't overstep their Brady obligations and turn it into something it never was intended to be. That's an easy one for us to agree and include. The fourth subdivision, again, examples of that. Work group working towards consistency, predictability, and security. Some of the retaining the classification of data, retaining that data security, but yet allowing prosecutors to do their job when it comes to also providing it during administrative background checks and other areas to comply with our obligations. It also creates some additional authority for district courts to step in and safeguard that information for law enforcement. It also creates a criminal action consistent with the MGDPA Chapter 13 for abuse or misuse of this data, this private sensitive personnel data. Again, consistency, predictability, security. Subdivision 5 is our commitment to notice, providing notice of and asking the court to provide notice when the courts make decisions that might have impact like this. Court decisions can have bearing, can be Brady-Giglio, but this also causes, and hopefully causes, a district court judge to make sure that they mean what they mean in their orders. If they mean it to have Brady-Giglio implications, this makes them mean it. Hopefully it causes them to pause, stop, think, and make a sound decision. I think to summarize, I think we've got a great framework for consistency, predictability, security, things that everybody has already testified to. Simple data access is the piece that we have to work on. It's not a simple answer, and that's why it's taking us a long time. Otherwise, on behalf of MCAA, we support this at this point.
Thank you. At this time, are there anyone else that wants to testify on this bill from the public? Not seeing any. Are there any questions for Chair Novotny or his testifiers regarding the bill? Representative Greenman.
Thank you, Mr. Chair. And just a question on the stakeholders that have been involved and consulted. I know that was a big topic of conversation last year. As a former public defender, I've seen that we have testifying law enforcement and prosecutors. I'm wondering how the public defenders, public defense bar, and defendants' rights organizations, how they have been engaged in this bill, or if they have in this version.
So I can address that just very briefly. I know our association's been in conversation with the chief public defender on this, and I talked to him following last year's hearing and got a little bit of input and perspective from him on that. We've wanted to make sure there's been alignment mostly on the side of prosecutors and the law enforcement agencies first. There may be an appropriate time for further input from other interested groups down the road.
Go ahead, Representative.
Thank you, Mr. Chair. So am I just correct in hearing that this language is alignment from prosecutors and law enforcement, but not the defense bar, defendants' rights, and public defenders? I know the defense bar is broader than public defenders.
Yeah, given that it's uniquely within the prosecution function and the executive branch function, we wanted to make sure there's alignment on that side before getting additional input. Thank you.
Anything else?
Yeah, just a quick comment, because I think the whole point of last session, we talked about a task force and just ensuring, I think we all share the goal of an agreement for a uniform standard. The hard part is what that standard is. And that is where I think it matters for the system to work, right? In an adversarial system, we need to ensure that the defense bar, that prosecutors, that law enforcement, and that folks representing the defendants, who ultimately, at the end of the day, it's their due process rights, are impacted. And so I know this is moving forward. I think it will be hard to support language coming onto the floor that doesn't include more than consultation, but some kind of agreement from all of those stakeholders. And I hope that that's the goal, because at the end of the day, doing justice and ensuring due process is what Brady-Giglio was about, and I hope that that's our goal too. Thank you.
Thank you. Chair Mueller.
Thank you, Mr. Chair, and thanks to Chair Novotny for your work on this. And I am prepared to support this today to keep it moving. And I definitely support the goals that have been stated. I do have another question about the stakeholders in addition to what Representative Greenman asked about. And I saw the letter in the packet from the League of Minnesota Cities and the Association of City Attorneys. And I called the league out yesterday because I didn't like their letter yesterday, but I did appreciate their letter today. And just want to make sure that they're also going to be included in the conversation. In addition to when I read the language and specifically at line 1.7 of the DE and 2.12, it talks about public employee and public employer, which is pretty broad. And so I think AFSCME and MAPE need to be part of that discussion. I'm thinking especially of folks that work in crime labs, you know, and I can think even more broadly, first responders that are public employees. I mean, obviously Brady-Giglio applies to all of those witnesses, but that's a pretty broad term. And so I just want to make sure all of the right folks are at the table as this bill moves forward. Thank you.
Thank you. Representative Pinto.
Thank you, Mr. Chair, and sorry to follow our Chair Moeller. I did want to follow up on the exchange between Representative Greenman and the county attorney, just that what I was hearing saying, it makes sense to me that sort of there needs to be some the issues are so complicated in this. There's rights of law enforcement officers, there's certainly rights of defendants. I'd say there's ethical obligations of attorneys. And so I understood what you'd be saying is that there has to be a conversation among law enforcement prosecutors just to figure out like what even would those groups want to support. And I think we're hearing that that's still being figured out. I guess the piece that I want to make sure to follow up on though was your comment that sort of that has to be figured out. And then it would make sense that we're going to hear from folks who represent criminal defendants, making sure that those rights are protected. If that's coming up in the process, that makes a lot of sense to me. We're moving this on to another committee. I do want to make sure in the course of things, though, that those groups do have input. There are conversations for the many reasons that that's an important thing to do. So not getting in the way of this today, and it sounds like the conversations are continuing. And again, it makes sense to me if we're going to start with police and prosecutors and add others in, as long as that does in fact happen. So thank you, and thank you, Chair Novotny, for your work on this and to the testifiers.
Thank you. Chair Novotny, closing comments.
Thank you, Chair Witte. As I prepared this bill, I thought back in my career and thought about the times that a simple mistake or a misunderstanding could have resulted in me being placed on one of these lists. Think about the time that I took a report on a weekend of a fairly serious past action assault and sexual assault that had happened. And of course, I did all the reports and took a statement. And at that time, and I'm going to date myself here, we were using handheld dictaphones with tapes. And you would put the little tape in an envelope and you would drop them in the secretary's box and, you know, mark it priority, and they'd get done right away Monday morning. Well, I'm working nights and I get a call about 10 o'clock on a Monday morning because the head of investigations had gone through the ICRs and saw that I took this report on the ICR, but they went looking for the tape and they couldn't find a tape. And on about 3 hours of sleep, I got a very angry phone call on why wasn't a report done. And, you know, in my sleep aroused stupor, you know, I did do the report and I did throw it in Donna's box, and immediately got up and was going to go into work to figure this out and do another report. And, you know, from the tone and tenor of the chief investigator, I was in big trouble. And before I could get to the office, the secretary had looked underneath her typewriter. That's how old it was. They were using an actual typewriter, and that tape was underneath the typewriter. Had that not been found, that could have, you know, how would that affected me? Would that be a very serious case? Would that have questioned my my reliability in going forward. And I also would like to point out that I didn't always have this easygoing, laissez-faire attitude that I have now. That there was a time when I was younger and I used to have run-ins with county attorneys and judges on cases, and how without a standard, getting on one county attorney or one judge's bad side, and I have done that both, just from my attitude that would result in me putting on this list and be a cloud over my career for the rest of my time. In all actuality, doing disciplines and doing terminations of employment as a supervisor, so many of these things that we look at based on truthfulness or, falsifying testimony, I believe most departments are like me now. If there's something that's really going to impair their ability to testify, they're going to be terminated before that. We want a uniform standard. It's been, the notes that I came up with before they even heard everybody talk. We want consistency, we want fairness, and we want it to be appealable, so that, one disagreement with one person won't result in a career being destroyed. So that's why it's important. This is mostly, and it really affects the state employees, the troopers, the game wardens, someone that's moving throughout the state. And we've seen past cases where you have a county attorney in one, or a judge in one county that has their view of how things were supposed to be handled, and you go to a different county attorney and they're not happy with how that past incident was happened, and all of a sudden you're on a list. We do have the commitment from all the stakeholders that were involved in this, that we're going to keep working on it. And I hope we can get to the point where we do have a statewide consistent standard. With that, I would appreciate your vote.
Thank you, Chair Novotny. Chair Novotny renews his motion that House File 962, as amended, is re-referred to the Judiciary Committee. All in favor, say aye. Aye. All opposed, say nay. Nay. Motion carries, and House File 962, as amended, is re-referred to Judiciary. Thank you, Chair Novotny, and to your testifiers. Next bill on the agenda is House File 3541, Representative Duran. Please come forward with your to the testifier table with your testifiers. And I will be your chair for a few more minutes. Representative Duran moves House File 3541 before the committee with a recommendation the bill is re-referred to the Committee on Transportation and Finance and Policy. And Representative Duran, I see you have an amendment coded A1. Please describe your amendment.
Thank you, Mr. Chair, and thank you for allowing me to present our House File 3541 today. The amendment is actually speaking and clarifying the boundaries and specific guidelines of where I guess we're identifying whether State Patrol would have authority for the investigations.
All in favor of adopting the A1 amendment, say aye. Aye. All those opposed, say nay. Motion carries and the A1 amendment is adopted. Representative Duran, please explain your bill.
Thank you, Mr. Chair, and thank you, committee, for allowing me to speak today in regards to House File 3541. House File 3541 came about some discussions from the Capitol Security Commission, along with some other conversations with local law enforcement agencies and representatives around campus here. There was a little bit of confusion in regards to where the State Patrol has the authority or should have the authority to investigate criminal behavior within inside the Capitol grounds. So this bill is actually made up to clarify the language, make sure no one has any issues or distinguish without the fault of their own. I think the legislation needed to be updated in regards to some clarification on what their tasks and duties are within the state Capitol grounds. So
Thank you. And I see you have one testifier, Colonel Chris.
I think she's just here for questioning
Okay,
if
sorry about
if
that.
anybody has any questions for her.
Is there any, are any member questions for Representative Duran or his testifier? Representative Feist.
Thank you. I just want to thank nonpartisan staff who are so awesome that they caught this typo that just happened to be in the law, where we were asking people to ensure orderly conduct, which seems impossible. So now they're going to ensure, which seems like more actionable. So it was John. Yeah. Nice job. That's awesome.
Any other further, Representative Steer?
Thank you, Mr. Chair. Representative Duran, does this any way stop like Ramsey County or St. Paul PD from doing an investigation on Capitol grounds if they're requested?
From my understanding, it does not, but if nonpartisan would clarify that for us.
Nonpartisan.
Mr. Chair and members, the bill does provide for the State Patrol and Capitol Security to request the assistance of another agency to take the lead on an investigation.
Any further questions? Chair Mueller?
Thank you, Mr. Chair. And I'm sorry if I missed this. A fiscal note has been requested. Is that right?
Mr. Wells?
Mr. Chair and members, a fiscal note has been requested. The dollars would affect the budget of the Transportation Committee, and I believe one will be ready by the time this bill gets there.
Chair Mueller? Closing remarks, Representative Duran.
Thank you very much.
Representative Duran renews his motion that House File 3541 as amended is re-referred to the Transportation. All in favor, say aye. Aye. All opposed, say nay. Motion carries and House File 3541 as amended is re-referred to Transportation. Representative Duran, you can stay at the testifier table because the next bill is also your bill. Representative Duran, would you like to move House File 2936 before the committee?
Yes, Chair.
Representative Duran, please explain your bill.
Thank you, Chair, and thank you, Committee, for allowing me to speak on House File 2936. This is also a bill in regards to the DOC and whether or not that there is any, I guess, policy or rulemaking that would actually increase the changes of $25,000 or more in regards to local jails, that it would have to go through a process before that policy is implemented. I believe we need to slow down on some of these things and have better look at how the DOC is affecting our local communities. So with that being said, I'll turn it over to the testifiers.
First testifier, state your name and begin your testimony.
Lon Teely, Steele County Sheriff. Chair Novotny, Chair Moeller, and members of the committees, good afternoon. My name is Lon Teely, and I serve as the elected fourth-term sheriff of Steele County, Minnesota. I'm also currently the president of the Minnesota Sheriff's Association, and I'm representing the 87 elected sheriffs of the state of Minnesota. I want to begin by thanking Representative Duran for his work on House File 2936. I appreciate his willingness to engage with sheriffs and county officials on what is frankly a very serious operational issue for jails across Minnesota. House File 2936 is about balance, accountability, and local decision-making. It's about ensuring when new jails rules are proposed by the Department of Corrections, the financial and operational realities of Minnesota county jails are considered. County jails are funded almost entirely by local property tax dollars. In Steele County and other counties across greater Minnesota, jail operations are paid for by people who live and work in our communities. That means when the state adopts new rules that significantly increase operational costs, those costs do not come from St. Paul. They come from directly local taxpayers. The current approach we are seeing from the Department of Corrections with the proposed amendments to Minnesota Rules, Chapter 2911, reflects what feels like a one-size-fits-all model. Minnesota jails are not all the same. Each jail varies widely in size, physical plant, staffing models, and population. What may be workable for a larger jail is not always practical or affordable for a smaller or mid-sized facility. 2936 provides a reasonable and measured solution. First, it requires the commissioner to determine whether a proposed new or amended rule costs more than $25,000 in the first year for a jail to implement. Second, if that threshold is exceeded, the bill gives counties a temporary option to opt out of the rule until it's specifically approved by legislature. This is discretionary. If a county believes the rule is appropriate and beneficial for its facility, it does nothing and the rule applies. But if the rule is tremendously costly and does not fit the operational facilities or realities of that jail, local officials can seek temporary relief until the legislature has had the opportunity to weigh in. This bill does not roll back any existing jail statute or rule. All current legal and constitutional requirements remain fully in effect. Our obligation to operate safe, constitutional facilities does not change. The standards that protect inmate rights and staff safety remain intact. What this bill addresses are new unfunded mandates. The draft rule amendments currently under consideration have the potential to add tens of millions of dollars statewide to county jail operations. This is not a small adjustment. That is a major financial impact to local government. Sheriffs, jail administrators, and county boards are in a far better position to understand the practical realities of their facilities than regulators who may be far removed from day-to-day operations. We operate jails 24 hours a day, 365 days a year. We are accountable directly to our communities for both safe and fiscal stewardship. House File 2936 also enhances legislative oversight. When rules carry significant fiscal consequences, elected representatives should have the opportunity to review and approve those impacts. That is appropriately accountability when local property taxpayers are footing the bill. This bill is needed now. The rulemaking process is already underway. If these rules move forward without meaningful and fiscal considerations, counties will face substantial and immediate cost increases without additional state funding. Let me be clear, sheriffs support reasonable standards. We support safe and constitutional jail operations. What we are asking for is flexibility and recognition that Minnesota's counties are not identical and that local decision makers should have a voice when expensive mandates are imposed. Chair Novotny and Chair Moeller, members of the committee, on behalf of the Minnesota Sheriff's Association, I ask for your support for House File 2936. Thank you.
Next up is Commissioner Snell. Welcome back, Commissioner Snell. State your name and begin your testimony.
Thank you, Mr. Chair and members. For the record, my name is Paul Schnell. I'm the Commissioner of Corrections. Thank you for your time today and for the opportunity to share a few perspectives on this bill. Shortly, you'll hear from our rulemaking director, Emilio Arcella, about the Administrative Procedure Act and the safeguards built into that process. I would encourage you to think about this from a policy perspective. But before that, I want to offer some context on how we got here. This proposal would fundamentally alter that longstanding structure by conditioning implementation of rules on a secondary legislative approval process if a certain cost threshold is met. That is a significant structural and policy shift regardless of the specific rule currently under consideration. First, I understand that this bill may be framed as a broader recalibration of the DOC's rulemaking authority, not tied to any one legislative act. But it is important to recognize that the department's authority to regulate jails is not new, nor is it discretionary. The legislature delegated that authority in 1976. The rules have been revised multiple times over the decades, including most recently in 2013, without a legislative approval trigger of this kind. So before we treat this as an abstract rulemaking debate, it's worth revisiting the policy decision that brought us here. In 2021, the legislature was grappling with how to make jails and prisons safer and more accountable. This committee heard from Minnesota Sheriff's Association, the Department of Corrections, and heartbreaking testimony from Brett Huber Sr. and Delshia Perry, two parents whose children died in Minnesota jails. And there was recognized a need to update minimum standards in jails. The legislature made a deliberate policy choice at that time, Rather than trying to draft highly technical operational standards directly into statute, the legislature directed the department to update the rule and engage in the rulemaking on 17 specific separate areas. The recognition at that time was that the statute was not always the best vehicle for nuanced, in-depth operational policy. Rulemaking is a necessarily robust process that relies on subject matter expertise, stakeholder engagement, public input, fiscal analysis, and independent review. That bill was passed out of this committee with unanimous support and then went on to passage in a divided legislature. In that same session, the legislature determined that prison security standards and external oversight were also important. They created the State Correctional Facility Security Audit Oversight Group and gave Minnesota Sheriff's Association a seat on that group. That public body develops security standards for DOC-operated prisons and reviews biennial audits. The legislative through line in 2021 was clear. Correction settings, both jails and prisons, required structured, thoughtful oversight mechanisms developed through collaborative processes and with external oversight. Now I want to address the policy issue at hand. It appears the concern driving this bill is that local jails face very real financial constraints when they are asked to do more with the same or fewer resources. That is a legitimate concern. Counties operate within tight budgets, and we understand that compliance requirements can have very real fiscal implications. When facilities are asked to absorb new responsibilities without corresponding investment, it creates strain. The DOC acknowledges that reality. We want counties to have the resources they need to have safe, secure, and professionally operated facilities. If there are funding gaps created by rule changes, policy conversations are necessary. But this bill does not help counties to address their resource needs or shortfalls. I fear that this bill introduces uncertainty into the rulemaking structure the legislature itself created. And I would offer one additional reality. Taxpayers will pay one way or another. In reviewing jail-related death settlements in just 5 counties, we know that approximately $17 million has been paid out since 2021. I don't mention this as an indictment of counties because it's occurred within DOC-operated facilities as well. It is a recognition that when systems are stretched and expectations outpace available resources, financial consequences will follow. And those costs are ultimately borne by counties and taxpayers. The depth and breadth of the rulemaking process is in part an effort to address areas of exposure and address them through establishment of standards. The policy question before you is not whether counties deserve support. They do. The question is whether altering rulemaking structure is the right mechanism to address resource concerns. If the concern is that any future rule adopted by the DOC may impose costs on local governments, that is a broader policy question about delegated rulemaking authority itself, not about this particular single rule package. And that is a conversation that extends well beyond the Department of Correction. If the legislature wishes to change the discretion they gave the DOC in the 2021 session to engage in rulemaking, we recognize that as your fundamental authority. If the legislature believes that rulemaking framework itself should change, that is a different and broader conversation. In 2021, the question before this committee was whether standards for jails and prisons needed to be strengthened. And the answer at that time was yes. Strengthened standards may come with operational and fiscal impacts. We stand ready to continue the rulemaking process in collaboration with the counties and with all of you. But clarity and consistency and legislative direction matter. Thank you, and I will now turn it over to Amy Lauricella, who will talk more about the process and our efforts to date.
Amy Lauricella, Department of Corrections Policy and Rulemaking Director. State your name and begin your testimony.
Thank you, Chair. Mr. Chair and members, for the record, my name is Amy Lauricella, and I'm the Policy and Rulemaking Director for the Department of Corrections. And I want to focus on process and structure. Exciting stuff, I know. Minnesota operates one of the most rigorous administrative rulemaking systems in the country under the Administrative Procedure Act. In fact, there's actually already a provision that looks quite similar to the one that you're considering today in that act. Under the framework, as you know, the legislature sets policy and statute and delegates authority to agencies to adopt rules within defined limits that you set. Agencies do not create policy independently. We implement what you direct. And before any rule can take effect, we must demonstrate that it's both needed and that it's reasonable. That means that we prepare a detailed statement of need and reasonableness, it's called a SONAR, that justifies every single provision of a proposed rule. And it must include a very rigorous cost analysis as well. Estimates of implementation costs to the agency required to inspect for it, compliance costs to affected parties, including local governments, the costs of not adopting the rule, consideration of less costly or less intrusive measures, and then also how flexibility for regulated parties has been incorporated into the rulemaking standard. We must consult stakeholders, provide public notice, publish the proposed rule, accept and respond to public comments, and submit the entire rulemaking record to an independent administrative law judge. In many cases, public hearings are also required. The judge reviews our statutory authority, the rule's reasonableness, and our compliance with every procedural requirement in the APA. If our rationale is unsupported, the rule can be disproved. That uniform structure balances legislative authority, agency expertise, transparency, and independent review. And House File 2936 would insert an additional approval layer, but only for one agency, and without mechanisms built into Chapter 14. This bill mirrors a concept already in statute. Section 14-127 requires legislative approval if the projected first-year compliance costs exceed $25,000 for a small business, which is defined as fewer than 50 employees, or a small city, which is defined as fewer than 10 employees. And there are some key exceptions and severability provisions that still permit those rules to take effect if they're in play. House File 2936 expands that concept beyond those carefully calibrated limits in 14-127, and it applies it uniquely to correctional facilities without incorporating those same safeguards. This raises three structural concerns. First, it disrupts the uniform framework of Chapter 14 without amending Chapter 14 itself. The APA is designed to create one consistent rulemaking process that applies to all agencies. This creates a separate approval standard for one. Second, it creates uncertainty about when a rule will become effective. Even after full APA compliance and independent judicial review, a rule's applicability would depend on separate legislative action. That alters the timing and sequencing of rulemaking in a way that's not contemplated by the existing framework. And then third, it expands a narrowly tailored cost-based mechanism beyond the entities that the legislature originally determined warranted those special protections, creating unequal treatment across agencies. If the legislature wishes to revisit the APA more broadly, that is certainly within your authority. But creating an agency-specific override risks redundancy, inconsistency, and fragmentation of a system that's deliberately designed to be uniformed and balanced. Minnesota's Administrative Procedure Act already provides rigorous cost analysis, public participation, independent review, and multiple avenues for legislative oversight. For those reasons, I encourage the committee to consider the structural implications of this proposal. Thank you.
That'll be it for the testimony. Is there anyone else who wishes to testify? We'll go to member questions. Representative Curran.
Thank you, Chair Novotny. Representative Duran, I'm trying to look at your face. Hi. A couple of questions for you. Are other state agencies subjected to this same standard, or would this just be for DOC?
Representative Duran.
Thank you, Mr. Chair, and thank you for the question. Would be just in regards to the DOC and the changes that they would be making.
Representative Curran.
Thank you. My general caution with something like this is that this legislature in particular is only in official session for about 4 months out of the year. So I guess my question to you, sort of in jest, is are you prepared to support a full-time legislature so that we can make sure that we're addressing changes promptly and not having to wait to enact them? I just want to make sure that while we're fitting in the work in such a short time that we already have to do, that we're not sort of like creating this sort of backlog of changes that need to happen because we're adding more into less time.
Representative Duran, please say you don't want to hear around your legislature.
Oh, what? You don't like being down here? Thank you for the question. No, I do not support an all year round legislation. As much as I like it down here, I don't like it as much as my hometown, so
Fair enough.
I like to be back up there. But I think it's going to actually slow down some of the processes and make people actually think about some of the consequences of the department's actions and how they move forward with some of the policies that they're changing. Now, this is what's happening right now is they may walk into a place and be like, all right, we're going to change this, 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 and this, and it's going to cost us a lot of money, or it's going to shut down your jail. So I think at this point in time, what we need to do is we just need to take a step back, slow things down, and kind of look at how these effects are going to not only just affect the county, because it's going to put a lot of people in jeopardy if we start changing these, because we don't have the resources or some of the, areas to adjust like maybe a bigger jail does when we're in smaller communities. So I think I think this is a good concept to kind of slow things down and look at things in a different light to make sure that we're not doing a one-size-fits-all that's going to fit every single jail, right? So I think this is a very good starting point for us to be able to slow things down and look at things. And I don't know if there's been a change that needed to happen right now. And, without looking at, the effects of things. So I think this is a good way for us to kind of look at things and what are the consequences that are going to come from some of these policy changes. Are we going to raise taxes? Are we going to close a jail? Are we going to need to create new policies for the jail and the sheriff's office? Are we going to have to hire more people? Are we going to be able to keep up to the standards that maybe they want when they don't understand that community or that jail? So it's just, I think this is a really good start for us.
Done. Chair Moeller.
Thank you, Mr. Chair. And I do have a question for the Director of the Rulemaking. I'm sorry, I forgot your last name. I don't have it in front of me. And I guess in response to the answer that Representative Duran just gave about jails having to comply with something this quickly and having to slow down. In my experience, the rulemaking process is a very slow process. And if you could just tell us if there's like an average time period that it takes from when a rule is proposed, going through the process until it's ready for prime time.
Laura Schella.
Sorry.
I was trying to get her title. Director Laura Schella.
Mr. Chair, members, thank you for the question. It can widely vary. The current rule that we're looking at least as it relates to the jails, 2911, is a ongoing 4-year process stemming from legislation that you all passed in 2021. There have been other rulemaking initiatives that we've undertaken that have been really targeted, small, minor changes, and those can take under a year. I think on average, we're probably looking at department rulemaking, probably 2 to 4 years is a typical timeframe. I also think it's important to know this jail rule, the 2911 jail rule, hasn't been revised since 2013. So it has been nearly 15 years since the most recent revision. And I think that's likely in large part as to why the legislature directed us to implement some updates to it in 2021.
Chair Moeller.
Thank you, Mr. Chair, and thanks for that. I do think that 2 to 4 time year average is a pretty slow and deliberative process. And I'm also really uncomfortable with applying this bill just to DOC for the reasons that were testified to about inconsistency and redundancy with Chapter 14 in that process, and just sort of a slippery slope. If we do it here, like what other areas of law are they going to try to have different rulemaking processes? And so I have some discomfort with that. And then, I just was thinking through how often in this legislature that we do pass costs on to counties. We get fiscal notes and it'll always say like local cost, but we never really factor that in. We don't have to factor that in for our budget. And I know specifically in the context of public safety, there are times where we increase penalties or we create new laws, new crimes, and a lot of times that will have a very direct impact on costs to counties, jail, prosecution, et cetera. And we don't, ask, and maybe we should look at that whole process about when we pass costs on to counties, certainly. But I'm uncomfortable doing it in this context. So, thank you.
Thank you, Chair Mueller. Before we close, Representative Duran, I'd just like to say that one of the things that, to piggyback on Chair Mueller, that has bugged me since I got here is the willingness to pass on cost to the locals. So I would agree with her on that. But to put this into perspective, I know one of the counties that I represent had designed their jail for a certain staffing level based on the design at the jail in agreement with the DOC to their standards when they built the jail. And then after the jail was built, they changed the staffing regulations and how that design of jail, what they would need for people to staff that jail at one time, minimum staffing. A simple move like that, adding one person to a staff, can be hundreds of thousands of dollars a year in cost. And, that was part of their rulemaking, but that's, I think, where a lot of the concern that the sheriffs have come into that. So maybe we can work on this, maybe change the levels of cost or something to make it more substantial as we move along. With that, closing arguments, Representative Duran.
Thank you very much for this. This bill isn't going to fix all the problems. This is not one of those bills that's going to solve all our issues and keep taxes low and everything else. No, this is not. This is what it's doing is it's actually allowing for people to look at some of the changes within our own communities that not one size is going to fit all. So I think as a legislation, we get into that where we have to make sure that we're passing a bill that's going to fit everybody, and that's not necessarily true in real life. There's stuff that happens in northern Minnesota that's a heck of a lot different than what happens down here in the cities, and we need to be cognizant of that. So with that being said, I appreciate that and hope for a yes vote.
Well, someday you might get it, but it isn't today because House File 2936 is being laid over. Thank you, Representative Duran, and to the testifiers for appearing today. The next bill on the agenda is 3762. Vice Chair Witte, please come to the testifiers table with your testifier. Vice Chair Witte moves House File 3762 before the committee with a recommendation that it is referred to it is re-referred to the General Register. There is an amendment to this bill, but we'll have the author explain his bill and his testifiers give their testimony before considering the amendment. Vice Chair Witte, please begin your testimony.
Thank you, Chair Novotny, and thank you, fellow committee members. Today I offer House File 28, Today I offer House File number 3762. It's authorizing chiefs of police and sheriffs to open certain expunged records to determine the eligibility to purchase, receive, or carry a firearms. This bill enforces existing laws. It does not create any new disqualifiers. It ensures issuing authorities can see records that may already make an applicant ineligible under current and state and federal statute. The narrow purpose specific access, this bill allows limited access to expunged data only for permit to carry and permit to acquire determinations, not for employment, housing, or general use. It's protecting the communities we serve. They complete the background information, helps prevent prohibitive individuals from lawfully obtaining permits, and strengthening the safety of our neighborhoods and the officers who respond to calls. And it's maintaining public confidence in the permit process. Victims, families, and the public expect that when a permit is issued, it is a thorough, accurate review as occurred. The bill enforces this trust and will prevent lawful gun ownership. And with that, I will turn it over to my testifier.
The testifier is Clay County Sheriff Empting. Sheriff, begin your testimony. State your name, please.
Chair Novotny, Chair Moeller, and members of the committee, thank you for the opportunity to speak today. My name is Mark Empting. I'm currently the Clay County Sheriff, which is in the Moorhead, Minnesota area. I'm here on behalf of the Minnesota Sheriff's Association, which represents all 87 elected sheriffs across our great state. I want to begin by being very clear about our intent. This proposal is not about expanding the list of disqualifiers for permit to carry or permit to acquire. It is not about restricting the rights of lawful gun owners. Our sheriffs support the Second Amendment, and we issue thousands of permits every year to responsible citizens. What this bill is about is our ability to enforce the law as it currently exists and to make sure that individuals who are legally prohibited from possessing firearms do not receive a permit simply because we were not allowed to see the full and accurate record. Under Minnesota's shall issue framework, a sheriff must issue a permit unless a disqualifier is found. We have a limited statutory window for permit to carry applications of 30 days to make that determination. The law places the responsibility squarely on the issuing authority to identify disqualifying criteria such as felony convictions, domestic assault convictions, qualifying violent misdemeanors, orders for protection, and mental health commitments. Our decisions are only as good as the information we are allowed to see. Right now, in many cases, we are making those decisions with what I would describe as a 10,000-foot view of the individual's history. Expunged records can limit or remove our access to information that may be directly relevant to firearm eligibility. That can include domestic-related conduct, weapons-related arrests, or patterns of threatening behavior that, when viewed in full context, could reveal a legal prohibition under state and federal law. Let me be clear. This is not an argument against expungement as a rehabilitation tool. Sheriffs believe in second chances. We work with people every day trying to rebuild their lives. But when it comes to the issuance of a permit that allows someone to carry a firearm in public across our great state, we have a statutory duty to ensure that the person is not prohibited. If a disqualifying event is sealed from us, we cannot lawfully deny that permit. And once the permit is issued, the public and other law enforcement officers reasonably assume that a complete background check was conducted. That creates a real and practical public safety concern. We have identified several operational gaps that this legislation seeks to address. Here are a couple. Expunged domestic-related offenses that may trigger federal firearms prohibitions are not always visible to the issuing authority. For example, a fifth-degree domestic assault is pled down to a disorderly conduct, and then it's expunged. Or felony-level conduct that is reduced and then expunged can remove critical context needed to determine eligibility. The result is that the sheriff who is legally responsible for that decision is sometimes making that decision without a full picture. House File 3762 is a narrow, targeted proposal. It does not change who qualifies for a permit. It does not add new disqualifiers. It simply clarifies that sheriffs, for the limited and specific purpose of determining firearm eligibility under Minnesota law, may access the information necessary to enforce the disqualifiers that the legislature has already enacted. This is about balance. We can support rehabilitation and expungement while still ensuring that firearm eligibility determinations are based on complete and accurate information. From a practical standpoint, this bill helps protect, number one, the integrity of the permit to carry process. Number two, the public's confidence that the background checks were thorough. The ability of sheriffs to meet their statutory responsibility. And number four would be the most important, the safety of our communities. Every permit we issue carries our name and our office's credibility. When we sign that permit, we are certifying that based on the information available to us, the person is not prohibited. We simply want to make sure that the information available to us is complete. Chair Novotny, Chair Moeller, and members, this is not about taking away rights from lawful citizens. It is about making sure that those who are legally prohibited do not receive a permit because of an information gap. And the Minnesota Sheriffs thank the author of the bill, Co-Vice Chair Representative Witte, for bringing the bill forward. On behalf of the Minnesota Sheriffs Association and the 87 elected sheriffs of this great state, I respectfully ask for your support of House File 3762. Thank you for your time and consideration.
Thank you, Sheriff. Members, questions? All right, moving on. Go ahead, or do we want to do the amendment first now? Yeah, let's do the amendment first. The amendment is A1. Who has that amendment?
I do, Mr. Chair.
Chair Moeller, describe your amendment.
Yes, so thank you, Chair. Well, I am going to withdraw the amendment, so I'll just start by that. And prepared to support this bill and agree with the testifier. This is basically a loophole that we need to close. And I think when we first looked at this, we were thinking about the crimes that are prohibitors and really trying to limit access to expunge records just for those crimes. And that's what we tried to do here with this amendment. But after we shared this with the sheriffs and they pointed out to the example you gave about a domestic that's pled down to disorderly conduct, wouldn't it be captured by this? And so really appreciated that feedback, and that's why I'm going to withdraw the amendment. I'll say that one of the concerns we had initially was looking at expunge records perhaps for like a drug crime that's a low-level misdemeanor, gross misdemeanor, and basing a denial on that when it's not a disqualifier. And I know there's a little bit of discretion in statute for both permit to purchase and permit to carry. And so that's what we were a little bit nervous about, but talking with nonpartisan staff more about what the process is if somebody's denied on a basis like that and the steps they can go through to challenge that, left me with a lot more comfort and to withdraw this. And I just, for the record, would love to have nonpartisan staff describe, for example, with a permit to purchase or a permit to carry, if somebody is denied and feels like it's an improper basis, what are the steps that they can go through to challenge that?
Mr. Diebel.
Mr. Chair and members, the process is similar in both statutes, but referring specifically to the permit to carry statute. If someone's denied, they have 20 business days to submit additional information to challenge the denial, and then the sheriff needs to respond within 15 days. And then if the sheriff did not change his or her mind and continue to invoke the authority to deny the application, then the applicant could apply to the district court in the district where they submitted their application, and the court would have to look at the file from freshly, so de novo, so they would have to take in all the information and make a ruling without regard to what the sheriff had. So they'd apply the standard that's set forth in statute with fresh eyes.
Chair Moeller.
Thank you, Mr. Chair. No, I think that's just important to have that on the record. And then I do have another question about the bill, and so I don't know if you want me to ask that now, since I'm withdrawing the amendment.
Questions on the bill? No, we're fine. We'll withdraw the amendment now.
Yes.
All right. With that, Chair Moeller withdraws her amendment. We'll go on to member questions. Representative Greenman.
Thank you, Mr. Chair. And this may be just a question of history, because I share the goal and appreciate the bill ensuring that background checks work the way we intend them to keep guns out of the hands of folks who are legally prohibited. I used to, when I was a public defender, also do a lot of pro bono expungements. And one of the challenges we had was the opposite issue of it was hard. The records seemed to be in the hands of everybody. And I'm just wondering how this loophole of law enforcement not being able to get the information, is that something that's been there for a while? Is that new, and did that come with the expungement law? I'm just sort of curious as to how long this issue of not being able to have access to the records existed.
Sheriff Empting.
Yes, thank you, Mr. Chair and Representative. This came about when the expungement law came through, so it hasn't been that long. It's just recently, was recently noticed through the expungements.
Representative Greenman?
Thank you, Mr. Chair. So I appreciate this, Representative Witte, and I appreciate that. And again, share the goals and appreciate the bill.
Representative Curran?
Thank you, Chair. Thank you, Representative Witte. I appreciate the bill as well. And I know today that your bill is addressing a loophole in the existing expungement process that we have. I'm curious if you would be open to knowing that we're prepared to support this because of the immediate impact on an important issue facing our communities. These are the laws we have, so we're going to work with them today. Curious if you would be willing to work on a long-term solution that would ultimately remove what you're doing today in favor of a step ahead of the expungement process or during the expungement process, whereby the information that law enforcement needs today would be sent over to NICS so they have it, rather than requiring opening records and looking at them and trying to discern what might qualify or disqualify.
Yeah,
Vice Chair Witte.
I'm always willing to discuss it to make the bill better. And I think when we, this bill is kind of opening up that communication piece with the courts and the sheriffs and the ability to make sure we get it right. So I'm always willing to discuss further on bills.
Representative Curran?
Yeah, thank you. And I think, you know, I think there's just obvious concerns when records that people have gone through such lengths to get expunged are opened up. There's concerns about that, and I think there's some legitimate concerns, but ultimately we're wanting to make sure that the wrong people aren't getting guns, right? So I think just long-term, my goal would be to try to see if there's a way we can do that without opening up records and do it before that record is created or as it's created, to send that information to a database. Similar to how, like when somebody's deemed incompetent to stand trial, that information is sent over to NICS and they're prohibited from having a firearm. Another, a concern related to that, that I have that is not a concern that neither you or I or anyone here can tackle today, is that I'm not sure that there's clear guidelines on the discretion involved in issuing permits when somebody's been placed on a list like that. So I just want to make sure that going forward, you know, when a law says, you know, if somebody is on, has been deemed incompetent for trial, for example, that they shall not receive a permit to purchase. That has happened in the past. And that happened in a big case several years ago, and that person went on to use that firearm to do the things they said they were going to do that landed them kind of in the spot they were in the first place. So I just want to make sure when we're talking about sort of some discretion in that process and issuing permits that the state is making it very clear and not putting that on sheriff's departments to sort of make that decision and saying, these are the points. If you meet this, you don't get a gun. If you meet this, you don't get a gun. So I'd just be happy to work with you on some of that.
Vice Chair Witte?
Thank you. I appreciate that because a lot of times they were put in tough spots when the permits come in. And you know from previous calls or just something didn't match up and you put it out there. That's why I think opening up the records and letting them see and having that deep dive gives them the confidence to back it up in the record. So we're not doing any undue harm. But like I said, I'm always willing to improve a bill so we get it right and we make a stronger legislation. So thank you.
Chair Moeller?
Thank you, Mr. Chair. I just had a question about effective date because I think the bill is silent and there's no cost. I believe the effective date would be August 1st. And so I'm wondering if at some point you want to amend it so it's effective upon enactment, as long as maybe check with the BCA first to make sure there's some reason that we're not unaware of that they couldn't do that. I don't know if we want to verify with nonpartisan that it is an August 1st.
Mr. Diebel?
Sorry, Mr. Chair, could you repeat the question, Chair Moeller?
So I assume that it's an August 1st effective date because the bill is silent.
Yeah, it's not, yes, Mr. Chair and members, it's not a finance bill, so it's a policy bill, so August 1st would be the effect.
And if I can, Mr. Debo, it is, I have seen in other bills where we make them effective upon enactment. And so that's language we've used in other situations.
Mr. Chair.
Mr. Debo.
And Chair Mueller, yes, that's a practice that is used when something's urgent and needs to be put into place quickly.
Yeah. Thank you, Mr.
Chair Mueller.
Yeah, thank you, Mr. Chair. Thank you, Mr. Debo, and Mr. Chair, may I?
Yes, go ahead,
Okay,
Chair.
thank you. Yeah, so I think, Vice Chair Witte, if you would double check with the BCA and see if that's something that, if you can make that change so that it'd be effective upon enactment, and there's no reason why they can't for with their systems or something, I think that would be great. And then I'm also just going to put a plug in for a bill that we'll be hearing most likely next week related to domestic violence cases and firearms. And part of that bill has the fact that somebody that's forbidden for having a gun because of domestic violence would have to surrender their permits in addition to their guns. So just going to put in a plug that we can continue this discussion next week as well. Thank you.
Vice Chair Witte.
Thank you.
That's your closing comment?
Thank you, committee.
Vice Chair Witte renews his motion that House File 3762 is referred to the General Register. All in favor signify by saying aye. Aye. All opposed say nay. Motion carries and House File 3762 is referred to the General Register. Thank you, Chair Witte, and to your testifiers. The next bill on the agenda is also your bill, so you can stay at the testifiers' table, Chair Witte. Vice Chair moves that House File 2879 be before the committee. Vice Chair Witte, I understand you have an author's amendment coded A1 that updates the effective date of your bill. Is that correct?
That's correct.
Vice Chair Witte moves adoption of the A1 amendment. All in favor signify by saying aye. Aye. Those opposed say nay. Motion carries and the amendment is adopted. Vice Chair Witte, please explain your bill and have your testifiers introduce yourself for the records.
Thank you, Chair Novotny. Thank you, fellow committee members. House File 2879 is a bill for an act relating to public safety, establishing an organized retail supply chain crimes advisory board, requiring a report, appropriate money, proposing ending for a new law. We have an opportunity, the Minnesota has a momentum, in 2023, organized retail crime definition law created a foundation. House File 2879 is the next step, moving from definition to execution and coordination. This is a bipartisan opportunity to shut down organized criminal enterprises, strengthening public safety, protect our communities, support businesses, and our tax base across Minnesota. The solution is a coordinated state response, bringing the experts to the table and working together, coordinating quickly across jurisdictions, and support dedicated resources and a clearer pathway to build enterprise-level cases. Identify patterns, track repeat offenders, and connect incidents across regions. Expanding training and best practices, and leverage resources more effectively. Committee, when we work together and we communicate together with all our different agencies, we are stronger. And I will turn it over to my testifiers. Thank you.
First testimony we have listed is Bruce Newstead of the Minnesota Retailers. State your name and begin your testimony.
Thank you, Mr. Chair and Chair Moeller. It's great to be here today. My name is Bruce Newstead with the Minnesota Retailers. We're a trade group that ranges from small locally owned stores to regional and national operators serving customers across the state. Just a quick thank you to Representative Witte and Representative Norris for their leadership on this bill. In your packet is a listing of actually 15 organizations that I want to draw your attention to that support this bill. I think you'll see it represents a wide-ranging impact of this problem that we're talking about today and an attempt to address those crimes. As you'll hear, organized retail and supply chain crime is not isolated. It's actually coordinated, it's sophisticated, and it's growing. These are not one-off petty thefts. These are criminal enterprises that are targeting every point in our supply chain, from warehouses to trucks to store shelves, from the ports to the railway. And this drives up costs for families, creates safety risks, and really disrupts Minnesota communities. These criminal enterprises, they can be multinational, and they often use the proceeds from their retail or supply chain crime to fund other nefarious activities such as drug trafficking and human trafficking, and sometimes even worse. Minnesota, as Representative Witte has said, has already taken an important step in defining organized retail crime statute in 2023. Thank you to many of you in the room, and Chair Novotny and Chair Moeller especially for that work in 2023. These criminal networks operate across jurisdictions, and our current system is simply too fragmented to keep up, and that is our challenge today, execution. House File 2879 addresses the gap by creating a coordinated statewide approach through an advisory board at the Bureau of Criminal Apprehension, bringing together law enforcement, prosecutors, labor, and industry to share, connect cases, and build enterprise-level prosecutions. We've seen actually how this model and some variations of it can work. Today at the BCA, there's the Minnesota Financial Crimes Task Force, and we've seen how that can be successful addressing complex crimes. And similar to this bill, 17 other states are doing some version of a task force with the same goal of addressing retail and supply chain crime, and they're seeing results, and those states range from California to Florida. This bill gives Minnesota a practical, proven path forward, and we appreciate you hearing it today. I will certainly end with an invitation to anyone on the committee. If you're interested in seeing how these organized crimes impact Minnesotans, we have retailers that would love to host you for a store visit. And Mr. Chair, we have a retailer and several partners here today to talk about the bill as well.
Next up is Karen Patero, District Manager for Patina. State your name and begin your testimony.
Good afternoon, Chair Novotny, Chair Moeller, and members of the committee. Thank you for the opportunity to testify. My name is Karen Tapero, and I'm the Director of Retail Operations with Patina Stores. I'm a first-time testifier, and I appreciate the chance to share our perspective on organized retail crime. Patina is a Minnesota-based retailer. We've been in business since 1993 with 8 locations across the metro and our headquarters in Minneapolis. Depending on the season, we employ between 200 and 300 people. Over the past 30 years, we've worked hard to create something special, a shopping environment that is inspiring, fun, and safe for both our customers and our staff. We're incredibly grateful for the support of our communities that they have shown us. I'm here today to share what organized retail crime actually looks like inside our stores and how it impacts our employees, operations, and the communities we serve. In 2024 and 2025, we had a repeat offender who stole from 3 of our locations. For a long time, she didn't raise suspicion, she blended in. But over time, patterns started to emerge, and we went back through our video logs. What we found was that she had been stealing consistently, and not just from us, but from other local retailers as well. She was targeting high-demand collectible plush products called Jellycat, and reselling them online through platforms. We also learned she was working with online clients, essentially taking shopping lists of items to steal. This was planned, coordinated behavior. This wasn't someone making a one-time mistake. This was targeted. We provided surveillance and information to law enforcement, and they did what they could. But these incidents occurred across multiple cities over time, which made it difficult to build a larger case. The impact on our business is real: lost product, time spent documenting and reporting, and an impact to our staff. And what's most frustrating is we know that it isn't isolated, but there's no clear way to connect these incidents across stores or jurisdictions. A second example involves a group of individuals who targeted multiple Patina locations. They were brazen. They came in with bags, filled them, and made it clear that they intended to steal. When our staff approached them, the situation escalated. They became confrontational and threatened violence. In 2 instances, our employees were assaulted. In another, the situation was stopped before it escalated further, but not before a direct threat was made. We began to recognize patterns, the same individuals, the same methods, even vehicles with stolen license plates. This wasn't happening at just one store, it was happening across many locations. Our employees could see it, they knew it was bigger than any one of our stores, but there's very little they can do, and we've made it clear that their safety comes first, always. Again, local law enforcement did what they could, but the reality is, we can see the pattern at the store level, but there's no system to act on it regionally or statewide or beyond that. I want to be clear, our local law enforcement partners are committed and responsive. About a year ago, the city of Roseville even began working toward an organized retail crime task force. That's progress, and we appreciate it, but we need more Rosevilles. Then we need to help those departments in a coordinated way. But the challenge is structural. As I understand it, cases are handled as individual incidents, not as part of a larger network. Jurisdictional boundaries make it difficult to connect cases, and building a broader case takes time during which these groups continue to operate. Without someone connecting the dots, these cases stay small, and the people behind them stay active. Make no mistake, these are organized groups with plans of their own level of coordination. What we're seeing in stores is often just the front end of a larger criminal operation. And the impact extends beyond our stores. Losses don't just disappear, they show up in higher prices. It affects how we staff and operate our stores. In some cases, it even forces businesses to question whether they can continue to operate in certain locations. When that happens, communities lose access, jobs, and the vibrancy that local retail brings. That's why this bill matters. House File 2789 helps move us from reacting to individual incidents to actually addressing the networks behind them. It supports coordination, improves sharing, and allows the faster identification of organized activity. From our perspective, that's the missing piece. I know we are a small retailer, and my stories aren't something you would likely read in the news, but this organized crime activity deeply impacts us, and it impacts others like us. We want to keep serving our communities. We want to continue creating spaces that are welcoming and offering great products to the neighbors we serve, but the state needs tools that match the scale and sophistication of what we're facing today. Thank you for your time and consideration, and I invite you to stop by a patina anytime. We'd love to serve you.
Next up, John Hauslein from the Minnesota Truckers Association. State your name and begin the testimony.
Yes, good afternoon, Mr. Chair, members of the committee. John Hauslein, President of the Minnesota Trucking Association, and I'm here today to testify in support of House File 2879. You've heard it already. These organized theft groups, many of them operating from foreign countries, target both cargo and data at every point in the supply chain. And they use a variety of sophisticated tactics, and some of these may not make sense, but okay, smash and grab, take the trailer, take the contents is one thing. But hijacking, fictitious pickups where they pretend to pick it up and don't, cyber attacks, GPS data spoofs, what's that? Pretending where you are somewhere where you're not, and flat out identity theft. And I think the thing that's important is we don't just move freight, we move data. And the technology we use to move freight efficiently and get it to our customers is the vulnerability that the bad guys have found. And what we find is in every transaction, think about this, you have a shipper, you have a receiver, you have a trucking company, you have a truck driver, oh yeah, and maybe in the middle you have a broker. Those are 5 parties whose identities are being stolen regularly as fleets have to deal with the fact that someone is saying that they're someone who they're not. And the technology is sophisticated. Now, you probably heard about Guy Fieri and Sammy Hagar's 2 truckloads of tequila. Anybody like tequila here? Stolen. $1 million value, 22,000 bottles stolen through organized theft. And that made big news, but I have to tell you, my members across Minnesota, from St. Cloud to Wilmer to St. Paul, are telling similar stories, and I can share them in detail. Whether it's a $22,000 theft or a $250,000 organized theft. Annually, that's a $35 billion loss nationally. And because supply chain theft takes place over multiple jurisdictions, we heard earlier testimony, Our members often face this very painful game of trying to find out some law enforcement agency somewhere who will listen. It's dispatched in one city. It's picked up in another city. It's delivered in another county, in another state. And we try to get help, and it's a lot of finger pointing and saying it's not our jurisdiction. And prosecutors say, what do we do? So that is a very challenging environment when you're the trucking company trying to figure out where to turn. So we believe that this advisory board created by this bill will provide the right framework to create this. And we just want to stress it is the supply chain from beginning to end. And this costs all Minnesotans. And one of the risks are adulterated product can go back into the market. It raises costs, pharmaceuticals, food, things like this. We have to cut this at the very beginning of it. And I guess I have some good news for you today. There are no opponents to this bill. It's only the bad guys. This is a true bipartisan bill that we can pass and make a meaningful difference, so we urge your support.
Thank you. Next up is Amanda Duran of the Minnesota Automotive Dealers Association. State your name and begin your testimony.
Thank you, Mr. Chair. My name is Amanda Duran, and I'm the Director of Government Affairs for the Minnesota Automobile Dealers Association, representing the state's franchise new car dealers. Over the past few years, dealers have witnessed a rise in sophisticated and organized crime. These aren't smash and grab crimes of opportunity like shoplifting, but are complex and premeditated. For example, wheel and tire thieves will target dealer lots and place cinder blocks under the stripped wheels so employees don't notice a difference in the vehicle's height. We've also had burglars use glass cutters to gain entry to a dealership, disable the alarm system, ransack the key boxes, and make off with several cars. And our association has been leading the effort in Congress to increase the federal criminal penalties for catalytic converter theft, an area where dealers have also been targets of organized criminal operations. Our biggest problem with battling these crimes is the lack of coordination amongst local law enforcement. Well-intentioned and hardworking investigators in individual cities will do their best, but as thieves hop from city to city, arrests are hard to make. In short, we need help and are asking the government to provide some basic coordination in their investigations. We think House File 2879 is a great first step, and thank Representative Witte for authoring this bill. Thank you.
Thank you. Members, questions? We have 8 minutes. First up is Representative Hudson.
Thank you, Mr. Chair. My question is for Mr. House-Lawton. You provided a good general overview of what you're experiencing in your industry, but I'm wondering if you have any specific case study or an example. It doesn't have to be something that actually happened, but maybe even a hypothetical description of the type of thing you're coming into
Mr. Chair,
contact with.
Mr. House.
Representative Hudson, thank you. No, I have a specific example. Coburn's out of St. Cloud, a purveyor of food, groceries, ordered some nuts and candies from Wilmer, Minnesota. The load was to be picked up in Wilmer, delivered to St. Cloud. From the time that the purchase order was generated and sent to the supplier, the bad actors had jumped into that technology and redrafted where it was to be delivered to. And instead of going to St. Cloud, Minnesota, it went to Sacramento, California. In real time, as it was being dispatched and it was getting ready to be delivered, they jumped in and did that. And again, you can imagine it being in California, and what set the alarm bells off was when the driver for the company asked for payment, and instead of it being a few $100s, it was a few $1,000s for the delivery of that truck, and that's when it was found. The warehouse that it was delivered to ultimately was determined to be a depot for electronics, food, and other things like this. So as we said, very sophisticated, and that's hometown. That was a $22,000 loss that could not be recouped by essentially the manufacturer in Wilmer. Thank you.
Representative Hudson.
Good.
Representative Fleiss. Oh, go ahead. Right, Vice Chair
Thank you
Witte.
for that question. The other part that's difficult about this, the victims are here in Minnesota, and you're trying to coordinate out in California. So who takes the jurisdiction, who takes the reports? And this is a way to cross them all together and work together and figure out the best kind of approach to tackle this. And I think the criminals know that. That's why this is happening this way.
Vice Chair Fleiss.
Yeah. Thank you so much, Mr. Chair. I've talked with the advocates briefly. I'm still I believe that this happened. I believe that the stories that are shared are true. And also, a lobster heist sounds like very dramatic in your handout. I'm just like, well, also I love patina. Just shout out to patina. Anyway, so like I believe that this happens, but ever since we passed our bill around organized retail theft, I've just, every time I see articles about it, I go down this rabbit hole. And there's so much conflicting data about it. There's good article or a study by the Brennan Center for Justice, kind of looking at the data. And one of the examples they give is that in recent years, Target closed a bunch of their stores. And they said in their statement it was due to organized retail crime, threatening the safety of our team and our guests. But then a subsequent study showed that actually those stores that they closed did not have any greater amount of theft than other stores. And so with respect to Target, maybe if people didn't feel afraid to shop or work there, that would help with their bottom line. But I just wanted to point out that there just really does seem to be some conflicting data out there. And when we're looking at how to invest our state dollars, this just seems like a really big response to something that clearly happens sometimes, but I'm just not convinced that it's like trending up and incredibly pervasive. So thank you.
Mr. Newstead.
Thank you, Mr. Chair. Representative Feitz. It's actually a great question, and I will admit just what you did too. I think we're relying less on national data because it is really hard to define this problem. I mean, we know Forbes says that Minnesota is a top 10 state for retail theft, but it's really hard when you start to dig into the data to localize it. So we're actually relying on the stories of Patina and some of our retailers to help kind of draw this conclusion that there is a big issue here. And I'm looking around the table. I'm not sure anybody here has been on one of our store tours, but we would, yes, oh yeah, I'm sorry, you both have. I think it is powerful to see what sort of these criminal networks look like in practice. And it's also easy to think, okay, this is a one-off kind of deal. The criminals that we're talking about are really career criminals. They're like the stuff you would see in movies, but the movies wouldn't be that exciting when you're stealing, diapers and baby formula. So I think my answer to that is, yeah, I think we're frustrated by national data too. It becomes very difficult, but we've seen enough and had enough conversations locally here with, again, stores like Patina. Like, you never would have guessed that a store like that, it falls victim to organized crime. But the reality today is the syndicate and the mob is different than it was in 1950. And instead of stealing lots of things from one store, there's a lot of small things stolen from a lot of different stores. And it's not just the big stores anymore. However, you can see some really, some of our members are really sophisticated in their collection of this information. And you can actually, we'd love to show you kind of like how does it work on a day-to-day basis? What are retailers looking for? What do they do when they find someone? Because we do have some real sophisticated operators, and I think, but I just want to acknowledge it is difficult to figure, like the data is really difficult to figure, and I'll be the first to admit, retailers don't want to talk about this stuff happening in their stores. The data is really, really difficult, but we'd be happy to show you kind of firsthand and in the field what it looks like.
Vice Chair Fleiss.
I'm good, thank you.
Can I respond?
Vice Chair Witte.
The other part is your local police department handles reports and then it gets pushed aside, and they might not have the capacity to go deeper into it. So sometimes I think it gets missed. So it might come up as just a regular shoplifting, but there's a bigger component to it. And so I love data, I love numbers, but sometimes it doesn't always compute to the right thing because we don't know how big things are getting. I will tell you personally, my daughter went out to the Mall of America just before the holidays. She walked in with her friends, used her car clicker. By the time she came back, her car was gone. It was smashed. They broke the window. They had a thing with the key thing. It was out at the Mall of America. It took off. Over 5 days, they caught the guys on the 5th day. They had a bunch of cars on a car loader up in Brooklyn Park that were going to be shipped over to Iraq. I never would have thought that was the case. I wish they didn't get the car on the car rack. I wish it would have got over to Iraq. It would have made insurance a lot easier. But that's another side story. But that's how you learn how this stuff happens. And Bloomington PD got in a pursuit with them and caught them as they crashed as they're leaving the mall. So these stories pop up, and just trying to connect the dots. That's why I think this advisory committee would be very, to figure out what it really looks like. But thank you for the question.
Representative Pinto.
Thank you, Mr. Chair. Vice Chair Witte, and to testifiers, I see in my work as a prosecutor, I think I do see the general need for this. It is notable to me that, and Representative Witte, you shared your own experience as a law enforcement officer, but we're mostly hearing from industry here. And just when first I'd be interested as to whether a DPS would itself have any thoughts on this. They couldn't take an official position in favor unless it's in the governor's budget, of course. But I guess I'd like to kind of get a sense, we have officers all throughout the state working on these crimes, have a sense from them to say, hey, boy, you know, what we really need is somebody, we need to be spending money on somebody to coordinate our work. Maybe they would say that. I don't know the cops I'm working with, and obviously I know Representative Witte, you're saying that, but I feel like I would find that especially useful and persuasive. It does make sense to me that there are sophisticated enterprises out there. Maybe part of the reason we've seen very few charges under the organized retail theft statute is that it is, as you say, they come in as a theft, you put them together, you charge just theft, and then you're kind of all done, maybe missing the bigger picture. But I do think that the officers handling that day after day, that'd be useful information for me to think that there is in fact a problem that this would in fact be solving. I guess that's all. Thank you, Chair.
Chair Moeller.
Thank you, Mr. Chair, and I'll start by saying that, yes, the thefts that were described are definitely a problem. I did have a question about how this could perhaps fit in already with the Financial Crimes Advisory Board, and I noticed that some of the language even in the bill, like I was specifically looking at lines 3.25 to 3.27 about multi-jurisdictional, statewide jurisdiction for the entities. And so I was wondering where that came from. And I am sitting next to nonpartisan, and that came from the Financial Crimes Advisory Board language. So I'm just sort of curious why that board can't actually do some of the things that you are requesting to do with this bill.
Mr. Newstead.
Thank you, Representative Mueller. It's a great question, and I think you astutely pointed out, we decided why replicate something where there's something kind of working, and that's probably why you see BCA as the placeholder. There are other states that have looked at the Attorney General's office. They've looked at California runs it out of their highway patrol. But we really looked for what's something that's sort of working where we could borrow a framework where it wouldn't be completely foreign. And so that's an astute observation. I'll just say we've had some great conversations with DPS, and we'll have some with BCA, and we'll see where we land on this relative to the department's thought on it. But I think we're really open. I mean, we're open to addressing the problem in a way that works for the state. And if there's some efficiency with combining it with something else or something like that, I don't see why we wouldn't do that. But
Chair Mueller.
Thank you, Mr. Chair. And just one final comment. I was noticing on line 1.16 and 2.3 that membership includes the U.S. Attorney's Office and also representative from federal law enforcement agency. And I guess I was surprised by that because we've heard a lot of discussion lately about whether or not we can force federal agents to participate with Minnesota law enforcement. So I'll just leave that comment there. Thank you, Mr. Chair.
Vice Chair Witte, closing comment.
I just want to thank the committee for the questions and the thought. Organized retail and supply crime is evolving, and Minnesota response must evolve with it. House File 2879 provides a practical, proven forward, coordinated statewide approach that brings together the right partners, focused resources where they are most effective and targets criminal enterprise driving this activity. This is about protecting Minnesota communities, supporting workers, ensuring a safe, reliable marketplace for consumers, and I thank you for your time.
Thank you. With that, House File 2879 is laid over. The next meeting of the House Public Safety Committee is Tuesday, March 10th, 2026. Chair Moeller, you will have the gavel. Being no further business before the committee, this meeting is adjourned.